Hello and welcome. The legal term for sedition classifies it as acts of rebellion against the establishment order. A broader definition interprets overt conduct such as speech or organisation that tends towards rebellion against established management, regardless of how manifestly corrupt and criminal that administration may be. The weaponised term sedition includes the subversion of a constitution, incitement of discontent or insurrection against a tyrannical authority, and non-violent turmoil. The literal meaning of sedition refers to speech or organisation that tends towards rebellion. Unlike treason, sedition does not necessarily involve violence, but may include any disturbance challenging governmental authority. The term originates from the Latin word sedition, meaning going apart, which historically referred to collective disobedience against a magistrate in the Roman Republic. The term sedition is now manipulated to take various forms, primarily through the deliberate misinterpretation of speech, writing, or organisation. This involves using anything spoken or written alerting the public to government-sponsored criminal actions, including genocide. When such expressions appear in print, no matter how truthful, they are denounced as seditious libel. Forming or participating in groups that aim to challenge the government are purposely misread as seditious. This includes planning to disrupt governmental functions such as the criminal enforcement of unsought, unnecessary and perilously harmful medical interventions. In other words, legitimate self-defence is now deemed seditious. While peaceful protests are generally protected, those that incite violence or rebellion against the state are considered seditious. But it's important to remember, deep state provocateurs instigate all the violence to provide an excuse to forcefully retaliate and furnish an endless stream of victims for the corrupt judiciary. Reporting what the establishment deems false information that might undermine governmental authority or incite public unrest is routinely weaponised by being deliberately misinterpreted as sedition. Using sedition as a broad brush of tyranny enables prosecution as a criminal offence, punishable by fines, imprisonment, or even death in extreme cases. Significantly, many young people unlawfully imprisoned by the misapplication of law often lose their lives through the violent rigours of prison environments, and the experience forever damages those who do survive. Governments corruptly use sedition laws to suppress dissent and silence opposition against such things as mandated medical procedures and smart city prisons. Stifling censorship crushes free speech while obliterating human rights and all inalienable democratic freedoms. Alleged acts of sedition are defined as increasing social unrest and instability by disrupting the status quo and challenging governmental authority. This oxymoronic ruse is instantly nullified by the fact that the only authority any so-called government has is exclusively derived from the informed consent of the governed. Outraged populations of countries worldwide have withdrawn this consent, citing the genocidal threat of Agenda 2030 and the satanic menace of digital IDs. Popular movements seeking to address important grievances are vilified and attacked, while legitimate opposition becomes increasingly difficult under intensifying oppression. Accordingly, self-defence, mislabelled as sedition, encompasses a wide range of activities aimed at challenging or replacing criminally usurped authority. Despotic rule by force has unconscionably criminalised non-violent dissent with grossly disproportionate legal and social consequences, being yet another venomous tentacle of globalism's predatory system. Once respected police services are crippled by pressuring officers to enforce illegal infringements and deploy gratuitous violence against peaceful demonstrators. Increasing numbers of morally sound, spiritually aware and critically thinking police have quit in an unprecedented mass exodus, thereby demoralising, undermining and ultimately sabotaging hitherto valid law enforcement services. This is the intention, since globalism's goal is the total destruction of human society. As previously reported, Australia has been deprived of the legitimate rule of law justly administered by authentic law enforcement for decades. This disastrous situation now takes a dramatic turn for the worse through the overt usurpation of the judiciary, law enforcement and the legislature by weaponising every aspect of all civic powers against us in a furtherance of genocide by any and all means. The doctrine of the separation of powers, which divides government responsibilities into distinct branches to limit any one branch from exercising the core functions of another, is fundamental to maintaining an effective system. However, the ongoing failure to implement and uphold this doctrine has fomented harmful consequences, undermining the workings of effective governance. The theory of separation of powers has profoundly influenced modern democratic governance. Montesquieu articulated the concept of separation of powers in his seminal work Esprit de Louis, where he identified three essential functions of government: legislative, executive and judicial. These functions correspond to Parliament, the Cabinet, supported by the public service, and the courts, respectively. The legislative function is prospective, prescriptive and general, while the judicial function is retrospective, determinative and specific. The executive function, which administers and enforces laws, does not fit neatly into a symmetrical framework, but is crucial for the balance of power. The tragic consequences of compromised separation undermine essential checks and balances. The separation of powers is designed to uphold distinctive areas of operation where each branch of government constrains the powers of the others. When this clearly delineated separation fails, one branch will unfailingly overstep its boundaries, leading to a destabilising power imbalance. In New South Wales, we see the catastrophic failure of this model, with countless lawsuits against the government being unlawfully delayed, frustrated and blocked. For instance, former barrister Julian Gillespie challenges issues relating to health and the medical autonomy, particularly concerning children. He's been battling these issues over the last 3 years while expressing deepening concerns about the legal process in Australia, highlighting conflicts of interest from a judiciary with no moral compass, especially in matters related to toxic jabs. Many condemn the court's never-ending delays as the contrived misapplication of the legal process. Meanwhile, judicial overreach, exacerbated by the undermining of the judiciary through being overrun and controlled by high-echelon pedophiles, sees judges making new laws instead of interpreting existing ones, resulting in fascistic judicial overreach. Conversely, legislative bodies routinely interfere with judicial processes, undermining the independence of the judiciary. The core tenet of globalism's controlled diminution of society has obliterated public trust in the legal system and irreparably compromised the authentic administration of justice. Without a clear separation of powers, the executive branch has become excessively powerful, leading to the current state of tyrannical authoritarianism. Historical examples such as the US Watergate scandal illustrate how executive overreach spirals into significant political crisis and corruption. In systems where the legislature fails to sufficiently check the executive, political instability invariably follows. The principle of mutual restraint, where each branch respects the boundaries of the others, is essential for a functioning democracy. When this principle is violated, legislative bodies recklessly enact laws that interfere with judicial decisions, while the executive abuses legislative oversight. This irretrievably undermines effective governance that not only fails to reflect the will of the people, but emphatically opposes it. Political paralysis and gross inefficiency see the ineffective separation of powers triggering policy immobilisation, where the legislative and executive branches are constantly at odds, leading to gridlock. This prevents any administration of the day from effectively addressing pressing issues and implementing workable policies, thereby undermining overall governance efficiency. In other words, in the exact same treasonous manner as countless other institutions, it's essentially sabotage. The effective separation of powers is crucial for maintaining a balanced and functional system. Corrupting this doctrine sees an untenable concentration of power, unlawful judicial overreach, excessive police powers, intensifying political instability, and a fatal disempowering of the people. Ensuring that each branch of government operates within its defined limits is essential for safeguarding a functioning nation. But unfortunately, we endure a belligerent occupation where a satanic global oligarchy has long since supplanted government for the people. They've ensured that the Australian population, the constitutional foundation of government, has no influence upon globalism's proxy misrule. This transcends sedition into the escalating spiritual war of biblical scope and historical consequence. Thank you for watching.